on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area.
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer. I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
it just happened right before your eyes. Good luck to you.
We're about to go to war.
This court hearing escalates quickly. Judge Urich, who doesn't tolerate nonsense, is dealing with a self-proclaimed sovereign citizen who's either pretending to be unstable or genuinely out of touch. He's facing 2 counts of public indecency after being caught exposing himself in a park. Let me know in the comments whether you think he's acting or truly unhinged. And if you enjoy content like this, don't forget to like and subscribe. Let's dive in.
Mr. Stringer does not acknowledge or consent to this hearing. Is that correct, Mr. Stringer?
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer.
Very well, Mr. Stringer. The court is going to read the charge into the record since the formal reading is not waived. Mr. Stringer, on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area, contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent B. The court advises you that this is referred to as a Tier 1 offense under the Sex Offender Registry Act. There is a count 2 misdemeanor in that on the same date you did knowingly make an open or indecent exposure of your person contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent A, commonly known as indecent exposure.
Sir, excuse me, sir. You have not talked to my beneficiary yet. You have not talked to the person who owns the estate yet.
Mr. Angot, the court is making a notation of court-appointed counsel to run through the IDSO office, and that new counsel, as appointed by Mr. Mena, can make whatever judgments they wish to make and make any motions they wish to make at Mr. Stringer's first probable cause conference. Mr. Stringer, this matter is now being set for a probable cause conference. That will be on a new date. The law entitles you to what they refer to as a preliminary examination within 21 days of this arraignment today.
He also has a lengthy criminal history out of Texas, going from as recent of these warrants, which were entered last year, back to around 2015, receiving charges for evading arrest and detention, unlawful possession of a firearm by a felon, assault, family, house member, impeding breath or circulation, several other assault charges, a weapons charge, and then also like falsifying assault from 2019 out of Parkwood Woods, which looks like it was deferred as assaulting a public officer or obstructing.
Judge, despite the fact of these charges and what was listed by the detective, I believe that with the GPS tether, that certainly would give this court, pretrial services, and any other entity overseeing Mr. Stringer during the pendency of this matter, notice of where he would be within 3 feet, is my understanding, with that tether. I don't think a cash bond is necessary. I would ask the court to give him a personal bond with the GPS tether.
Given everything that's before the court at this time, the court will set bond in the amount of $50,000, cash or surety, no 10% allowed at this time.
I have to say, this judge is incredibly good at his job. I've seen plenty of other judges try to handle these sovereign citizen types, and they either get frustrated or end up wasting a ton of time. But Judge Urich shuts that nonsense down fast. And honestly, the way he calls out the contradictions in their arguments is low-key hilarious. He has this subtle but effective way of putting them in their place. The $50,000 bond was also a solid decision. This guy already has multiple felony charges, and he's still young. He definitely doesn't need to be back on the streets anytime soon. Hopefully he can turn things around, but I'm not sure. He genuinely seems mentally unstable, though I can't tell if he's acting or not. What do you all think? Anyway, let's get back into it.
Mr. Stringer wishes to bring various motions before the examining judge. And that could include a motion to modify his bond. That is his right and his privilege. But at this time, that is the bond as set by this court. Mr. Stringer, that concludes your arraignment, sir.
Sir, so I can't get out on a personal bond?
That's correct, Mr. Stringer. You cannot get out on a personal bond. 50,000 cash or surety with the appropriate conditions that were already listed by the court. That completes your arraignment, sir.
Sir, so what is going on with what is going on? Right?
I'm sorry, sir?
I'm being charged. How do you charge an entity that is...
Can you please move up so the court could hear you?
I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
It just happened right before your eyes. The court has jurisdiction over you, sir. Venue and jurisdiction have been established by sworn testimony. That completes your arraignment. Good luck to you.
We're about to go to war.
I'm not sure if you all caught that in the first hearing, but he literally said, "We're about to go to war." That has to be one of the dumbest things I've ever heard someone say to a judge. If I were the judge, I would have hit him with contempt on the spot. Now we're about to jump into his second hearing, and this time it's in front of a different judge who does not hold back. Things get heated fast. Let me know what you thought about the first hearing. Now let's dive into the second one.
All right, Mr. Stringer, state your name.
I don't acknowledge myself as Derek Stringer. I'm a living entity.
Okay, is there another name that you go by, sir?
A living entity, I'm the beneficiary, so I go as a job. And I want to fire that counsel. I don't want him.
All right, so there's a number of things to unpack here. All right, so let's walk through this. So did he make it known to you that he wished to no longer proceed with your services?
Judge, we discussed the case fully, and I had a lengthy phone call with one of his relatives, and it was my intention to ask the court to refer this to the Forensic Center for a competency evaluation.
I do think it, given your experience and then your connection with him as well as a family member, plus the way the defendant has presented today, that a competency review is in order. And so I'm happy to move forward with that. So Mr. Stringer, there is, just so you understand, there has been some preliminary information that suggests that you may not be competent to proceed at this particular time. Whether that's a correct assertion is basically a decision that can only be made after an investigation is done to determine whether or not you can, that you understand the nature of the proceedings, that you can assist your attorney. We need to find those things out. And so, Ms. Mott-Lewis, can you prepare an order for competency review?
Do you think the competency review judge is making the right call by placing this defendant under evaluation? If you didn't know, when a defendant wants to fire their attorney, it becomes a major issue if they're mentally incompetent. Without a lawyer, they can't properly defend themselves. And even though this guy thinks he's some sort of genius, it's pretty clear he's dealing with mental health issues. Situations like this slow the entire process down and can even violate a defendant's right to a fair trial, which could lead to the charges being dismissed. Plus, if they don't understand the charges or how the legal system works, it's like trying to play chess with someone who doesn't even know the rules. Complete chaos. Let's get back to it.
I'm going to wait to consider that request until I can determine whether or not he's competent. If I would remove Mr. Sanutko off the file, if I would remove him off the file based on a request made by a person who's later determined to be incompetent, I think that would be a real issue. And so at this point in time, I'm going to grant the request.
What labels, excuse me,
Evaluation.
What labels me incompetent? My intelligence, because I have a high IQ?
No. That's not it, sir. There are different legal standards, but really it comes down to whether or not you can understand the nature of the proceedings at this time, that you have the ability.
I overstand the nature of the proceedings.
That you have the ability to assist your attorney in your defense.
To withdraw, sir. I do not want my legal counsel. Actually, he did not reach out to the person that my relative told him to reach out to my father, and he didn't do that. My father was going to tell him that we wanted him to withdraw. He did not reach out to my father. He only reached out to Stephen Taylor. Stephen Taylor gave him my father's number. He did not do that. So I would like him to withdraw from my case, sir. I have no. So he isn't competent enough for me, honestly.
I'm almost certain this competency review is going to show that this guy is dealing with some serious mental health issues. He's already stacked up multiple felonies, and it honestly feels like the cycle is just going to continue. Don't get me wrong, I believe in second chances, but it seems like he's already burned through an entire pile of them. And I still can't decide whether he's genuinely mentally ill or just acting like a typical sovereign citizen who thinks the law doesn't apply to him. The fact that he was caught messing with himself in public definitely makes me lean toward the he might be unstable side. What do you all think? Did the judges in this case handle things the right way? Personally, I think they did everything they could. Maybe holding him in contempt would have snapped him out of it, but who knows? Let me know your thoughts in the comments, and if you enjoy content like this, don't forget to like and subscribe. Thanks so much for watching, take care.